Keep your responses coming. We're getting a lot of tweets and emails on this story. Dr. Subramanian Swamy, President of the Janata Party, says law is for retribution and retribution there must be. And debating with him today, Shazia Elmi, member of the Aam Aadmi Party. And to her left is Malavika Rajkotia, senior advocate. To Malavika Rajkotia's left is Anant Astana, lawyer and an expert on juvenile justice. He has a contrary view to Subramanian Swamy's. Also joining us, Aryaman Sundaram, senior advocate, Supreme Court, Nina Naik, member of the NCPCR. And Kiran Bedi, thank you very much. Ladies and gentlemen, let's open the debate. My first question to Dr. Subramanian Swamy is this. You say make an example of this, but the law is not made for one example, Dr. Subramanian Swamy. The law is made for all. And if you say make this an example, this example will apply to all others who are also minors.
Well, first of all, there is a question as what is the law? This 18 years is recommended by whom? The preamble or the objects and reasons of the Act says that we are acting according to the Beijing rules and the UN Convention on the Rights of Child. Now, nowhere is it mentioned there that it should be 18. In fact, the Beijing rule number 4 actually says that you should determine the age according to
What is the definition of a juvenile?
Well, I'll read it out to you.
What is the definition of a juvenile?
I'll read it out to you.
Yeah, please.
Beijing rule 4 says that the beginning of the age of criminal responsibility, that is above the juvenile status, shall not be fixed too low and an age level bearing in mind the facts of mental and intellectual maturity.
Yes.
Now, where did this 18 come from? It's not internationally common. England has 10, United States has 14.
So what figure would you like?
I would say let it be 18.
No, then?
But subject to the assessment that whether he was intellectually and mentally capable of committing that act.
Who makes that? That's a very ambiguous assessment.
That is the, no please, you can read that out, you can go to court and get that read into the law. I did it in the Prevention Corruption Act. The Supreme Court read into it that the sanction should be given for prosecution within 3 months. Otherwise, it should be assumed that you got the sanction. It is not there in the Act. The Supreme Court read it out.
The argument put on the other side is that, you can make a popular case, but a popular case need not always be applicable in law. Nobody more than you, esteemed lawyer himself, should be aware of that, Dr. Subramanian Swamy. In this case, however, I'd like to ask, on the other side, to Aryaman Sundaram. Aryaman Sundaram, to those who say that there should not be a change, which I presume in this case includes you, am I correct?
That there should not be a change.
Am I correct? You are among those who say, Aryaman Sundaram, that the law should not be changed.
No, I'm sorry, I must make something very clear, because I do believe that this definition of juvenile is completely artificial. Unfortunately, under Section 2K, they say juvenile or child is 18 years and therefore everything else follows. On the contrary, let me make it very clear. I believe that this unfortunate immunity is nothing more than them being able to act with impunity. And it's got very far-reaching consequences. A case like this really tells a lot of delinquents, and I won't just say delinquents, I'll say hardened criminals who are old enough to know that what they're doing is committing a crime, committing a dastardly, vicious, wicked crime, old enough to know it, mature enough to know it. And if you look at the Indian Penal Code with a complete mens rea, with a complete intent, with a complete knowledge, and yet because of this artificial 18 years old, they are just tried totally differently.
So what about the United Nations rules? What about the United Nations rules? Sorry, I'm just playing devil's advocate. There's a United Nations rules, there's a Supreme Court which has ruled that the age of a juvenile accused should be ascertained on the day of the crime. On the day of this crime, this man, this young man or this child or minor, whoever, was 17 years.
It is a fact.
6 months and something.
That is again interpretation.
That's again interpretation. You are completely correct.
And that is to be tested in court.
The law is your age on the date of the crime. Allow me to finish, please. The law is your age on the date of the crime, which is why we have this farcical situation coming up. But that is the law and that is the correct law. It has to be the age on the date of the crime. But I'm saying on the date of the crime, the way to test whether a person should be tried for his crimes and punished in the way he ought to be punished is to see his maturity, his knowledge, his intent, whether he had the mens rea, and not merely whether he was 17 years, 364 days old, or 17 years and 365 days old. And I say that is where we are making a big mistake. And a case
the
like
Juvenile
this,
Justice Act is of the year 2000. Where was Subramanian Swamy and Aryaman Sundaram till now?
Is going to give a terrible message to everybody else.
We never thought that we would.
At least for the
it's
future.
always a question of a test case.
Okay, gentlemen, let's get the other view. Kiran Bedi, the law should not be changed. That's the argument being put forth. You are, of course, with Aryaman Sundaram and Subramanian Swamy on this. So before I come to you, I'd like to go to Malavika Rajkotia and to Anant Asthana.
It is a rare occasion when I and Sundaram have got together.
You haven't got together, you only agreed on one point. Getting together with you would make Aryaman Sundaram a politician. I think he'd desist that temptation from you.
A saffron politician.
And a saffron politician. We can discuss that later. The question is this. Malavika Rajkotia and Anant Asthana, the minor who is considered in this case was the most barbaric of the lot.
Yeah.
We don't know that.
No, this is
inquiry is going on.
Let us say.
You don't know that.
Why the accusation?
Why let us say
The
that?
question is to me. I'm ready to answer
let's
that.
take it.
Yeah.
1 minute. Let me complete. Well, you say I don't know. Well, you have no idea either whether he was or not.
Yes.
The press reports say he was the most.
But it is the accusation.
Now my point is this. He raped the victim and he assaulted her. And I don't want to go into the horrific details even after she was unconscious. The horrific nature of the crime, the magnitude of the crime, he gets away with 3 months. He's old enough to brutally...
3 years.
3 years. He's old enough to brutally assault somebody to the point of killing the person.
Yeah.
Pull the person's intestines out, leave the person in a completely physically...
Don't picture it more. We've read it often enough.
Then why, if you're old enough to do that, why do you suddenly become a juvenile?
In fact, what is apparent, and I have a view on this, what is apparent is his immaturity. Please, don't we know that children can about be the most cruel people? Haven't you read Lord of the Flies?
This is not some innocent act of school bullying, I'm sorry.
Lord of the Flies was brutal murder.
No, I'm not talking about
committed by ill-formed egos
I'm not talking
and
about
children anxious to please.
That is fiction. That is fiction.
It is a fiction that reflected reality, and why it was a Nobel Prize winner was only because it understood children.
Well,
why? Somewhere, Arnabh, we are going to have to take responsibility for our parenting.
Well, I'm sorry.
And as parents betray for society.
This whole argument that should be pushed back to society. I don't know whether you believe
society must take I'll give you a small example. 3 days ago, I find clearly an underage child on a two-wheeler trying to overtake my car. I follow him, I get to his doorstep, I ring the doorbell and I tell the mother that he shouldn't be out on the road. The response that I get is, leave him alone, his father died just day before yesterday.
Ms. Rajkotia. Bottom line. Ms. Rajkotia, bottom line is this. And I picked the argument with you. The minor in this case is 17-and-a-half-year-old.
That's fine.
Right,
yes.
1 second.
Horrible, very...
No. I'm saying precedent. Their argument of how many 17-and-a-half-year-olds will be emboldened if this fellow gets away. And what will happen to him? He'll be sentenced for 3 years if found guilty. Even then, he will not be lodged in Tihar jail, but he'll be kept at a reformatory home. Even if he's held guilty after turning 18, he cannot be kept in a correction home. A juvenile who has turned 18 cannot be transferred to jail because the law does not allow those tried under the Juvenile Justice Act. Aryaman Sundaram, this is true, to be kept in a jail meant for adults. No. Effectively, the most barbaric of the lot faces a few months' time in a reform home before he's set free.
Effectively, the most barbaric of the lot is because he's not adult. There is an informed ego. There is a problem.
You're making a virtue of his being 5 months short of age.
It's not a virtue. It's a position. It's a position with regard to how children are and why they need to be dealt with differently.
A child is what child does. And I think he's just 6 months short. Can you look at the difference? Either he gets 3 months maximum punishment, which he does in this, which he does, or he gets life imprisonment. So 6 months have saved you so much. I mean, look at the difference between the two punishment. And that is a huge issue. I don't think we should be Lakir ka Fakir. I think laws should be revisited. And they should be Lakir ka Fakir. There's a law is 18
just for
and
people
under.
who don't get the Hindi translation of them. What do you mean
just
by
sticking
Lakir?
to the law. Written in stone.
Yeah, it's not carved in stone.
Yeah.
And I think the social scientists, educators, reformists, people who look at even penitentiary and reform homes should consider the fact that if a boy was old enough to do something like this, to be as depraved as he was, to do something so horrific, surely 3 months maximum punishment is not enough.
Kiran Bedi, where do you stand on this? Kiran Bedi, should this, do you agree with Malavika Rajkotia's argument tonight that in fact the boy committed this crime? He raped the girl in this manner, with this degree of brutality, because he was a minor. Because he was a child.
You've sort of made it very
but this is exactly
non-contextual. But what I'm saying is it implies an immaturity.
You have tried to make an argument about the innocence of the child and the child not being aware. My point to you tonight.
I am saying he might well be aware. Now, 18-year-old, we all have 18-year-olds, we've got to that age by now. They're very well aware. But the point is there is still that degree of nurturing, still that degree of strength, self-esteem that is required, which society, acting as parents' patria, is not able to do.
I'll get Kiran.
And do you know the concept of parents' patria?
No, but this is not a self-esteem issue. You can't say the child lacked self-esteem and hence he carried out this crime.
For sure.
Well, Kiran Bedi, you've heard the argument of Malavika Rajkotia and also of our other introductory panelists. Where do you stand on this? Should the severity of the crime have no consequence in this case?
First of all, I have to say that there's an inherent flaw in this Juvenile Justice Act. It's never meant for punishment. It says the juvenile justice, care and protection of children. It doesn't really want to punish the child. It just wants to reform and correct the child. So I think we need to go back to say juvenile justice, care, protection, reform and punishment also act. I think that's what it is. It's the punishment component is totally missing. This is one. So there is a need to revisit the law. Second, Arnabh, if you give me a moment, I'm going to tell you something different. And that is, when I read the section 20 of this act, there is an amendment of section 29, and it says that the restoration and protection of the child means restoration to parents, adopted parents, foster parents, guardian, fit person, and one more word. It says fit institution. That means this man, the rapist, the savage, can be sent to a fit institution. Now, what is a fit institution? It's not been defined into this act. That means it is open for interpretation. What is a fit institution? Now, how could you go to a fit institution? Fit institution can be based on a Section 215 report. That says based on an investigation report. Now, social investigation report. Who does this investigation report go to? The state government. Now, the state government takes cognizance of this social report, and then under the oversight of a probation officer in protective custody can go to Tihar. For me, the courts, by high courts invoking their extraordinary jurisdiction power, interpretation power.
Miss Bedi, I have a very layman argument. I have a very layman argument.
Let me complete.
I have a very basic argument.
Arnabh, let me complete.
My basic argument is this.
Let me complete.
But
Let me complete.
Okay, complete, and then I'll come in. Yes, please complete.
I think it's a very good case for the extraordinary power of the High Court. Listen, I'm also a law graduate. I also read law. I've been a police officer 35 years applying law. What I'm trying to say is it's a case for extraordinary interpretation. What is a fit institution? In my case, in this case, the fit institution can be interpreted now as a prison where this person gets protective custody with the probation officer oversight and exclusive place. This is what I'm trying to say.
I'll come to you. I have two hands go up. I have two hands go up in the course of this debate. I haven't got to Nina Naik. She wants to say something. Before that, I'm letting Ariman Sundaram come in. Yes, Ariman Sundaram. Ariman Sundaram, your response, please. I saw your hand go up a couple of times when Kiran Bedi was speaking.
Yeah. Arnabh, I've heard this repeated reference to 3 years. I'm slightly lost here because, I've been going through this act also like Ms. Bedi has. And let me say that I find under Section 15G that actually when there is a crime based on the seriousness, the nature of the crime, and when the juvenile is over 16, they can be punished for at least 2 years. There is no maximum, although section 16 says they cannot be given death or life imprisonment. But again, there's a proviso to that section which says, but they can be sent to a special home even after they turn major, they continue. And they would be in that special home, which is equivalent to a special jail. One moment. But there doesn't seem to be a 3-year limit. I'm trying to find where you keep talking about a 3-year limit.
On a point of fact, Mr. Sundaram. On a point of fact. Just a point of fact, Section 15G of the Juvenile Justice Care and Protection Act mandates that a juvenile between 16 and 18, if convicted of any offence, can be sentenced to be sent to a special home for a period of 3 years at the maximum and thereafter be released on probation. Section 16, which you referred to, says a juvenile can be kept in the special home till he turns 18 and cannot be sent to jail thereafter, which in effect will result in his release. Effectively, the person is set free. Therefore, by consequence, I am not hyping this.
But he's in a special home, is he not?
It appears that a boy, it appears that a boy who picks pockets and a boy who commits rape is subjected to the same law and will be back on the street in a few months.
Rather than spending so much time reading...
I feel the act must be amended, but there are enough loopholes in the act.
What juveniles...
No, Mr. Sundaram is not satisfied with my argument. What have I said factually wrong, sir? Mr. Sundaram?
No, I'll tell you what I find, Arnabh, when I look at it, I find that it is not a case of wiping out an offence, so to speak. It recognizes an offence. There is also proviso by which, when we say send them to a special home, the special home looked at in many ways is almost like a form of imprisonment. I am not satisfied with the act. I believe the act should be amended. I believe these people who know what they're doing should be tried just the way as any other criminal and punished the same way. The act needs to be amended. But unfortunately, any amendment will not help in the case of this particular crime because it cannot be made retrospective. That's where I'm saying there are some loopholes in the act. There are some ways in which we can get into the act to see that there is a confinement to a special home for a relatively long period of time.
Mr. Sundaram, 1 minute. Mr. Sundaram, my next question is to Anant Asthana. Nina Naik, I'm coming to you. Please, just give me a minute. Mr. Asthana, does it not seem ridiculous to you that a boy who picks pockets and a boy who commits rape, if they are of the age of 17 years, 11 months and 28 days, will be subject to effectively the same degree of punishment? Does it not appear complete? And that boy will be back on the streets in a few months. My question, will you feel secure? Will you feel secure with that boy out on the streets, say 6 months from now?
Right. See, for somebody who is concerned with prevention of juvenile delinquency, this kind of panic is not an answer.
What's the panic?
It's the panic that the children are committing serious offences, send them to jail, hang them, right?
But they haven't they?
It does not work.
So why do you call it panic?
It's a panic. It's a panic which is being created.
So Subramanian Swamy is reacting in a panic-stricken manner.
Subramanian Swamy has his own view. I respect that. I mean, maybe we need to hear him when we amend the law. But then
define panic.
Right.
Define panic.
See, panic is that everybody is believing it's only 33,000 children.
3,000
Can't we take care of them?
No. My question is, why do you feel there is panic? I mean, if today, address the viewer today who says, I don't want this boy. No, I don't want this boy.
Panic is being created the way it's what created in the United States. Many people who became victim of that panic regretted it after 30 years. That, okay, we were wrong.
In the United States, minors can be treated like adults in exceptional cases.
United States is not a good model.
And that applies in the United Kingdom as well, sir.
280% swell in the prisons. United States is not a model we should look at.
So what is the model we should look at?
What is the
32,000.
That's all.
In the entire country.
Why can't
in
we
America,
take care of them? I agree. That's precisely what I'm saying.
The kind of offense.
There is a role of the state.
There is no comparison.
This is an indicator of failure of state. We aren't looking at this one child.
Arnabh, I want to clarify.
Why haven't either you or Mr. Asthana answered my question? My question is very direct. I have two questions.
Yes.
One, please answer. Don't answer my question directly.
Yes, I will answer.
If this boy comes out and he lives in a particular locality, will the women in that locality feel safe knowing that the person who did this to Nirbhaya is living in their locality. That's one minute. And the law can't always be on the side of the accused.
Right.
The law has to be on the side of the victim and potential victim.
Yes.
That is question number 1 to you. And question number 2, I'll ask later. Can I get an answer from you on this, please?
The first question.
Yeah.
First question was?
Will people in that locality feel safe?
Yes. I had dealt with a boy who wanted to be Dawood Ibrahim. Now he is doing Devi Jagran in Haryana.
So what do you say that 3 months?
So provided we take care of these children who want to be Dawood Ibrahim. We take care. We took care of them. He is reformed. Society is much safer.
So the general principle that we should see that juveniles committing crimes should be reformed so that they don't spend the rest of their life on a crime which they didn't know about or didn't know the implications about. But here it's a totally different case. This whatever I have seen he's been accused of, because I am in the court, I know his real name too, and whatever the police has produced on the basis of what they've heard, plus what the girl before dying gave in handwritten notes, all these put together show it was a deliberate act. He took pleasure. He didn't rape her once, he raped her twice. And then what he did afterwards is, just as you said, is indescribable. He has to be made an example. On the question of reform, on the question of seeing boys who steal bicycles and pastries and pickpockets, yes, we should try to reform them.
And my second question on that is to Nina Naik. Nina Naik, tomorrow if others aged 17 years, 11 months and 29 days carry out such incidents, are we to assume the law will apply in the same manner? Maybe they'll spend 2-3 days in a reform home and then be out on the streets. What kind of a law is this?
See, first of all, Arnabh, I must tell you that's unnecessary. We're really disturbed by this media frenzy that all of you are creating. There is a law. There is a law that has come up after much discussion at the national, international level. Now, this child, if he has committed a crime, we have to have a cut-off day. If you say a child of 14, if you see a child in Britain who has committed a heinous crime at 12, will you put him in prison? Isn't that some age? So we have, internationally and nationally, we have agreed. And if you look at a child of 18, he needs care and protection. Who is the parent's patria? It is the state. What has the state done to protect such children? And you've taken one isolated case, one child who has done this, and you want to reform the law. I think this is really very disturbing. You're trying to go all of you in the media are just making a one big issue of this child. Let's start looking at
why are you saying isolated case?
What happened to
why are you saying isolated case? Miss Naik, NCRB data shows rapes committed by juveniles have jumped up by 188%.
Incorrect. It's totally incorrect. It's only
5%.
Most of those cases are
look at the figures selectively.
Where children get into love.
I'll share the data with you. NCRB data for 2011.
Only 3.5%.
NCRB data for 2011.
No, NCRB data is wrong. I say it on record. It's wrong. It's wrong.
If the data doesn't suit you, you say it's wrong.
Delhi data 3.5%.
No, this doesn't suit you. He's a specialist in the matter.
No, I have got, there's no question of specialist in this. NCRB data shows
a boy runs away with a girl in a romantic relation. That is counted as rape. Most of the cases, I have dealt 4,000 cases. Most of the cases are those cases. Okay. Hardly any case.
I'll pick up one case with you. Let's pick up one case.
Yeah, there are cases.
No, let's pick up one case. Yes. Let's pick up one case and let's not deal with this theoretically. In America, there was a person called Lionel Alexander Tate. He's the youngest American citizen ever sentenced to life imprisonment without possibility of parole. When he was 14-year-old, he was convicted of first-degree murder for the 1999 battering of 6-year-old Tiffany. This happened in Florida. My question to you is, how would this be dealt with in India? The battering of a 6-year-old. In 2012, another case I can tell you, where a 13-year-old was accused of beating a half-brother to death while sexually abusing another aged 5. How would this be dealt with in India?
Right.
How would this be dealt with?
It has to be dealt with.
You want me to give you more examples? The 15-year-old was charged as an adult.
It has to be dealt with according to the law that we have here.
We are discussing whether the law needs to be changed.
No, but now then you're giving us American incident about why law should be changed here.
Malika, why should the law be constant?
It needs to be changed.
Why should the law be constant?
I agree with you, but then talk in a context. Now you're talking about these. You're giving us American incidents.
Here's the Indian context.
Let's talk of Indian. You're talking of how would India have dealt with if that was American. America. I mean, that's...
The Indian context is what has happened in December.
This one case.
Which you also were very enraged about. It's not one case.
I am.
It's not one case. There is a rising number of crimes committed by juveniles.
No, the population is also rising. Please, don't get the data in isolation.
The tipping point for this discussion has been this case. So now let's not talk about detailed...
Malvika, doesn't it bother you that this whole thing of one size fits all is a bit of a problem?
No.
In case of heinous crimes, shouldn't there be a qualifier?
No, may I say,
even where the law is concerned, when you look at somebody with criminal tendencies who's done criminal acts, and he's 6 months short. And this is according to
you, but you know what bothers me more? What bothers me more is too much margin of discretion. If there is a law, we have to stay with it. But and if there is a cutoff, I mean, the entrance into university is 99.5, and if you get 99.3, that's the cutoff.
A high-risk youth is different from a low-risk youth. The nature of crime is different from each other. Look at the nature of crime. Look at what is done. Look at what a child is, how you define a child and a juvenile. And look at what the justice system is supposed to achieve.
I want to go to Kiran Bedi. Kiran Bedi, let's hear your argument back. You're hearing a very strong defense being made here. Don't throw American statistics at us.
Yeah,
but I'm not throwing American. I threw Indian statistics. Then you said the Indian statistics are wrong.
Because he had counted.
I give you American.
Yes, the rape statistics.
Mr. Astana, with all respect to you, Mr. Astana, you had not a single answer to me when I spoke about American cases. And therefore, let me ask you one or two Indian cases. I'm sure you're aware. You're a specialist, as Malavika says.
Please.
In the July 2012 case of the Rohini murders in Delhi, the main accused was a 20-year-old, am I right? Mahesh, along with his accomplices, murdered 2 elderly women in Rohini 2 years back. Just a few months short, perhaps. Let off as a
Tell us, she said 9:35.
Appropriate or inappropriate?
Yes, that's
appropriate. Let him off.
That's what the reason.
So let him go back on the street.
16 to 18 year is the most volatile age where they are more prone to be guided by the adults. And that was it happened in this case.
Well,
also,
Kiran Bedi, let's get Kiran Bedi. The argument being put by Mr. Astana is 16 to 18 years. Coming to the other panel, 16 to 18 years is a very
difficult age.
Difficult age, yes.
And they want approval from adults.
All of us have done
if
crimes.
They want approval from adults, let me tell you, they don't seek the approval of adults before going and raping and killing people.
The adults were there.
Well, in the Dombivli eve-teasing case, when a youth was trying to protect a girl,
Arnabh, tell me a single case where a juvenile alone has done a serious offense.
That's the point.
Tell me a single case.
There is a whole concept of a juvenile trying to mirror an adult.
I'll tell you more than one case, but I'd like to get Kiran Bedi's response to yours. Kiran Bedi, you heard this argument strongly put out in defense of the accused. Where do you stand, ma'am? Your response, Kiran Bedi.
Arnabh? All right, then, Mike, since I have to excuse myself another few minutes, I wanted to leave this last argument here. That is, public memory is desperately short. When on 16th of December, the cruelty which happened on Nirbhay, I think everybody was gunning for the lives of all these accused. Everybody. Today, where is the victim? Where is the victim in this whole thing? I think we are thinking that the accused is a victim now. If we say that the fit institution could be a custodial institution like Tihar jail, and the state government could take or high court could use extraordinary powers in this, we think if we are considered as thinking out of our hat, and that the victim, which is the accused, we are now making a victim out of the accused. That's my plea. I think the public memory is terribly short. I'm so sad to hear that. I think we must keep the victim central in this and make sure that the real accused is punished under the extraordinary powers of the High Court, or there's a liberal interpretation to an institution called fit institution. I think the fit institution, in fact, for the safety of this juvenile, would be a safe place, a corner inside the hard jail where he goes through reform. That's it.
Arnabh,
I'll talk about reform in some time. Nina Naik wanted to rebut you. Go ahead, Ms. Naik.
Let's conceptualize this whole the accountability and responsibility of this juvenile. What is that? Let's look at the wider human ambit, the human rights ambit in which he was. What about his background? What about his upbringing? What about the education? You stop education at 14, right to education stops there. What do these children do? The 16 to 18, such a vulnerable age group. They are under the influence. Let's accept it that they're susceptible to influence. That even though 18,
we want to take this fellow home to reform him. 1 second.
There is a whole range of services, range of punishments.
Let me tell you one thing. Neera Naik, let me tell you a little bit. Miss Naik, hear me please for a minute. Please hear me for a minute. Indulge me for a minute, ma'am. Let me tell you a couple of things. I also want to share this with Malavika Rajkotia and Anant Asthana and yourself, who are taking a sympathetic view. Now, this is what the SIT did. The SIT says, because we are talking here about whether this fellow was doing something under some instruction, not aware, young boy, confused, low self-esteem problems, society to blame, etc. The SIT accused this boy of luring the victim. He's the principal person in trapping the victim and her friend in the bus. And how did he do that? Because he pretended it was a public bus and the passengers are there. So that's his first act. Secondly, Mr. Asthana, he was the person who passed lewd remarks at the victim and also taunted her friend. What is he doing so late in the night with a girl, he said. This is the quote. 1 minute. Third, he was drunk. Perhaps you will now say he was drunk and hence he was not in a state to discern what he was doing, and he was also drunk because of sociological reasons. He sexually assaulted the victim. He brutally tortured the girl. He was the one who attacked her with an iron rod. And the other accused have said that he was the one who was egging them to carry out more and more brutality on Nirbhaya.
So
you won't believe the police either?
Unless the decision comes.
She's made her statement in writing and her testimony is there, as well as the boy's testimony, and they both have testified to the fact that indeed
the rule of law
this young boy was extremely brutal.
The inquiry is pending. Inquiry is pending. Let the rule of law prevail in this country. How come we are making the presumption?
The purpose of today's debate is only whether this act needs to be revisited, and this
that is the question.
highlights that case to be revisited.
Tell me one thing, Malavika. Laws have been changed before?
I agree.
Laws change according to context.
But then we cannot discuss the details of this case, which hasn't even been a trial.
It's a very bad case.
I'm saying laws have been changed before. Why can't the law be changed in this particular
because
case?
It's a very bad case for changing the law.
Laws have been changed before and they should change if they need to be changed. But they should not be changed because of one case.
Well, let me...
You are dramatizing one case to say that's enough.
Malavika, I'm sorry if you say dramatizing. There's no dramatizing. It is pure, straightforward reporting and asking of questions.
Of a case where a trial has not begun, Arnabh.
Yes, how can we be presuming? Let me inquiry.
I understand your concern, and you're talking about human rights. But I always ask this question: that what about the human rights of the victims?
Yes,
and potential.
That's
victims.
a valid question.
And today, across the country, what about their human rights?
That's true.
This is the question. Always, if we put this point of view, no, let's be more sympathetic. Let's reform. Some things can be reformed. Some things need to be punished. And a society that does not punish or lacks the courage to punish runs the risk of having the same incidents being repeated again. We'll discuss this again 6 months from now. Quick last word, 5 minutes left on the debate. Subramanian Swamy.
Hopefully we don't have to discuss
Hopefully we don't have to.
Please, let's finish on that.
Hopefully we don't have to, but let's not live in a world where we believe these incidents don't happen.
Yeah.
Subramanian Swamy.
Well, it's a badly drafted law. And
no, it's not. It's very intelligently drafted law.
I have read the standing committee report. And unfortunately, that time the law ministry intervened and brought this 18. 18 is nowhere in the UN conventions. And therefore, we have to revisit it, and that can be done by reading into the law what the Supreme Court can do and the High Court can do to say what are the exceptions that 18 means an act of a juvenile. And if it turns out that he was mature, he was emotionally, intellectually mature, then he would be tried under the normal IPC. Incidentally, the IPC has placed the age at 12. Where anyone over 12 will be tried under the APC.
No, there is a lot of misinformation. The UNCRC says...
I'll give you one example.
Let me say, there is a lot of misinformation. The person will be out. No, he will not be out. So read section 3, which allows that in an inquiry in respect of a person who ceases to be a juvenile will continue as if the person would have been a juvenile, and then orders will be passed. He will be entitled, right?
No, I want to present 2 cases. I have 2 case studies.
Yes.
One, because you are arguing so strongly, and I come back to it's a Dombivli eve-teasing case. I am asking a question today: who is the law on behalf of the accused or the victim, and do we fight too hard? Do informed groups fight too hard on behalf of the accused always? And has it become fashionable to only fight on behalf of the accused and not on the victim? 1 minute. Example today. Dombivli eve-teasing case. One youth was killed for trying to protect a girl. 4 out of the 5 accused were minors. And hence, once presented in the juvenile court, what happened? It was said they will be released after they turn 18. Now,
no, it's not correct.
1 minute, please.
It's not correct law.
This is exactly what happened in the Dombivli case. Please, you can't question me on fact. My facts are absolutely correct.
Okay, please.
And let me tell you on this.
Please.
I'll share the facts with you after. No, I am never wrong on these facts. Please listen to me. Let me tell you one thing. Listen to my story. Why am I asking you this question? The boy who died, mother is a cancer patient. Father passed away 2 years ago, forcing him to be the sole breadwinner of the family. Is this the justice that our law will provide? To a boy whose mother is a cancer patient, father passed 2 years ago, forcing him to be the sole breadwinner of a family, killed for trying to protect a girl. Where is the justice?
Yes, law has to
where is the justice?
Justice has to be there. There is a victim compensation law coming.
Compensation?
It's there.
Compensation.
If you hang this boy, what will come to the
I'm saying, let's get Shazia. How would you deal with that case?
I think there's crimes like these, they're beyond compensation. Something like this, the only compensation can be actual punishment and tough punishment and making an example of it. I understand that you feel somebody is a child, but child is what child does. I think there is a need to make a case and a kind of a qualifier when it comes to 18-year age in terms of the kind of crime that has been committed. It's important. I understand you don't want life imprisonment, you don't want death punishment. I understand that, but I'm saying 3 years is nothing. So change that. Let's revisit it. Laws are not holy gospel.
Let there be a positive debate on that.
They should address the needs and addresses and concerns.
I'm requesting to understand that this is not. This is not a case in isolation. Malavika, I disagree with you there because, with all respect, because in December 2012, there was another case in Meghalaya, went a little unnoticed. I think this was a gang rape of an 18-year-old. There were 8 there. 8 were juveniles who carried out the gang rape between the ages of 13 and 17. 8 of them. In June 2012, and I'm again telling you, there was a young woman from Tripura. So you don't want me to talk about these instances?
I mean, I can also give counter instances.
No, I'm giving you instances. You are responding to my instances. No, I'm talking about cases where rapes and murders have happened. I'm obviously not talking about cases where they have not happened. If you're presenting the contrary case, I am presenting cases where rapes, because the argument is this is. It happens, you're drawing an exception, you're hyping it, or it's someone saying, dramatizing it. Where's the dramatizing in this?
No, the proposition is, do you want juvenile crime to increase or do you want to control it?
No,
JJ Act is on that. If you implement it properly, juvenile crime will come down.
If 18 is an age, it has been obviously done with some development, with some thought and address.
What thought?
The statement of objects and reasons which is that it's in consonance with the United States rights of child.
And I read out what the United Nations said. It has got nothing to do with 18.
No,
it's
sir,
just
you're totally wrong.
And intellectual maturity. That's there in
Sir, with due respect, you are totally wrong on this. UNCRC did say...
I'm always totally wrong, but what are you right on? What I want to know.
Sir,
you're on the side of a rapist.
Well, for once I'm on your side, Mr. Swamy.
UNCRC reading is totally wrong from your part, sir. UNCRC did say that... Anyway.
Couple of minutes on the debate. Nina Naik has been disagreeing very loudly as we've been debating this. Nina Naik, has Subramanian Swamy brought you over to his side on this debate here? Because these instances are not unique. They are not happening only once in a while. None of the cases I've presented are isolated cases, Nina Naik. Why can't we change the law?
Rule 3.
These are very few cases, Arnabh. Let's see, just a system's failure. We need to have proper systems in place. I wish to move your argument to another side in favor of children. Let's talk about the 170 million children in our country who need care and protection. Let's talk about the street child. How many of your panelists have actually interacted with such children? Why can't we do both? Have you seen the kind of...
Why can't we do both?
Can you see the...
No, why can't we do both?
We are doing both.
Let's change the whole...
Why can't we, Nina Naik, why can't we change the law, make the law a little bit more stringent at the same time, improve the correctional facilities?
The law is very well thought of.
Mutually exclusive of each other, they can be done together.
They're being done together. They're being done together.
No, I'm sorry, Arnabh, you're just trying to sensationalize this case. All that we have done for 70 years to protect the rights of our children, you're trying to bring it down in one argument. We're just getting a few people who've never interacted with children at that level. How many of your panelists have talked to children on the street? How many of them have visited their homes?
This was no child. This was not an act of a child.
The kind of abuse that
this was action of a seasoned, hardened criminal.
No, it's a typical juvenile.
One second. First of all, let me say this with the utmost respect, Nina Naik, that it is very easy to shoot the messenger. It is inappropriate for you, ma'am, to say we are sensationalizing this case. I can tell you that the last thing anybody would do is sensationalize cases.
No, it's happening. It's happening or not.
Please,
matter of concern for us.
We have to have you open yourself up to the argument on all sides, and we'll open up this debate.
We are
This is not the
concerned
first
about
debate
it,
we'll have on this. Let's have a proper debate and a detailed debate.
And you're talking about this, about these children.
Nina Naik, please can I just ask one thing? Can I ask you one thing? Okay, can I ask you one thing? Can I ask you one thing, ma'am? I want to ask you one thing.
Yeah, tell me.
Tell me this. Tell me one thing, Nina Naik. Can this fellow who has carried out in this state, egged on others, forced the assault, trapped the girl, carried out the brutality, carried out the most horrific rape and murder of this girl, can this fellow be corrected in 3 or 4 months? Tell me.
Yes. Many of them have been corrected.
Okay, so
it may take 10 years.
But even then, you have to revisit the law.
No.
You have to revisit the law.
You'd say that this fellow will be out in 3 years.
No.
At the most.
At the most. There would still be supervision. There would still be all of those things.
No, please don't talk about
supervision. And you are looking at possible. Can you say of an 18-year-old human being that he is beyond reform? Ask Kiran Bedi this question.
Let me ask the question.
The case of Chambal have been reformed. What about this child?
My question, please, that's all. My question is, can this fellow be reformed in 1 minute?
100%, Arnabh, 100%.
Or 1 year, 3 months, give me a precise time.
See, I am not the one who will give the time. The councillors will.
No, I don't think it's relevant whether he can be reformed or not.
Of course it is. It's the only question.
I think he has to be made an example of. You can have.
Now.
That is what I am saying. That is my concept of law.
I'm sorry.
That here is a person who cannot be forgiven. Even if he has got scope for reform, no.
Who is asking
he has
for
to pay. I am going to court and do it.
This is the most dangerous sort of argument, which is what erodes our criminal justice system. You cannot have people being made an example of without regard to the scope and parameters of reform.
I think the answer lies somewhere in the middle. While I don't believe in the bleeding hearts fighting for human rights of the accused, also this very bloodthirsty mob, violence kind of a thing. The answer has to be in the middle. The answer and the sense of outrage that the whole community, the whole nation has felt.
Let's hang him.
Let her complete. And we're not just talking about any person.
The sense of outrage that the whole community has felt has to be addressed. There has to be a sense of closure. It has to be a balance between this bloodthirsty, mob crazy approach and this bleeding heart approach that let's be.
No, we are not asking him to be hanged and lynched. We are saying through the court, hang him.
Well, one last thing I'd say at the very end.
I agree. Let the matter be in the courts.
This fellow, I'm not calling him a juvenile or a child. I find nothing childlike in what he did.
Monster.
This monster.
I mean, how you are presuming that?
I am looking by what the Delhi police
said. Now, if you say believe in rule of law,
the problem is
prima facie monster.
Mr.
Do you believe in rule of law?
Yes, say prima facie monster.
Then let the judgment come.
Mr. Astana, the problem is that with your line of argument, and I believe in the rule of law, by the way.
But you are passing judgment without inquiry.
Mr. Astana, I am a law-abiding citizen. And I have a right to ask you, as a law-abiding citizen, whether you think that this fellow, what he's done, is monstrous or not. And 1 minute, please. And then let me also tell you, this fellow, he subjected, according to the police, the maximum sexual abuse on 3 occasions. Once after she was unconscious. I don't want to say about what he did with the internal body parts of the person. And he is the one who said, throw her out of the bus. He is the one who said, remove her clothes. He is the one who engaged in the most barbarism. And therefore, if you're going to be so sensitive to him today, I'm going to ask you whether it's time for you to correct the way.
No, I'm all for that girl suffering as well. My heart bleeds for that girl suffering. I mean, I can't sleep when I think of the suffering which the girl had.
She can't suffer no more.
But
She's dead.
Is it okay for a rule of law based society to jump into these kind of judgments?
Yes, but a rule of law based society.
Police has said something. Let the honorable court decide and let the law take its own course.
Yeah, the law. That's what we are saying.
Are we a khap panchayat that we can pass on judgment?
Certainly not. What are we debating here today? I don't think you understood, Mr. Asthana, what we are debating. I can repeat it for you.
No, he understood it very well.
I am only asking you today whether the law can be amended. That's all.
Law needs to be amended.
Now the question is, Ariman Sundaram wanted a word. One second, Ariman Sundaram, before I close the debate. I'm already over time, but Ariman Sundaram, yes, please.
Arnabh, this law, according to me, is completely flawed. It is a law which does not take into account the nature of the offence. Yeah. If you notice certain sections, they do talk about the seriousness of the offence, the kind of offence, and it does show that the act itself has somewhere behind it looking at what kind of offence it is. I think it's a ridiculous discussion. Assume that Kasab was 17 and a half years. What would everybody's reaction be? Would everybody say he's a juvenile, poor chap, he must be looked after? The point is, did the person who's doing the crime know he was committing it? Is he mature enough to know it? And what was the nature of the crime? There are some crimes you can pass and say this is you can reform. But there are other crimes which demand retribution. In any society, the theory of punishment has three aspects: retributive, deterrent and reformative. We cannot throw out the other two just for one. And I fully agree that children should be corrected. According to me, a lot of people, even adult criminals in this country, commit crimes because of a very sad environment from which they come. But the fact is, we really have to look at A, the nature of the crime, the seriousness of the crime, and secondly, we've got to look at the maturity and the knowledge of the person who's committing the crime. We cannot impose any arbitrary age limit and forget about the reality.
I have only, Mr. Sundaram, as I close this debate, I'd only like to say one thing. All the time we talk about compassion and empathy for the accused. For once, let's have some compassion and empathy for the victims and all those who feel like potential victims.
Yes.
Our position by think that we don't have compassion and empathy for the victims.
I did not. I have mentioned a statement, and it was not meant to provoke you. Malavika Rajkotia, Mr. Asthana, Shazia, Subramanian Swamy, we agree to disagree. Ms. Naik, we can agree to disagree, and we'll have a bigger debate on this. We've all had our appropriate says on this debate, and let me tell you this issue matters to the people, and we will debate it again. We will call all sides. Let's see where this entire story goes. And as I debate this, let me also say the recommendations of the Justice Verma Committee are also with the government. If the government is serious, let the government do something about it. We'll follow that up as well.